Nations like Australia and Canada are federal nations, with power distributed between the national government and the state governments. This sometimes presents a challenge for international law because the basic assumption of international law is that each national government will have the powers necessary to carry out its treaty obligations. In Australia, the Tasmanian Dams case established that the Commonwealth can implement legislation necessary to give effect to treaties. In Canada, things were a little more complicated. The British North America Act 1867, a key part of the Canadian Constitution, said, "The Parliament and Government of Canada shall have all powers necessary or proper for performing the obligations of Canada, or any province thereof, as part of the British Empire, towards foreign countries, arising under treaties between the Empire and such foreign countries." After the First World War, Great Britain wound back its empire and gave full, equal status to all former dominions. Canada obtained the full ability to make treaties independently, not merely as part of the British Empire. So the British North America Act was a little out of date. It was never updated to reflect Canada entering into treaties that had nothing to do with the Empire. In the 1920s, Canada entered into multilateral treaties established by the new International Labour Organization. These required domestic legislation to give them effect. The Canadian government passed legislation, but Ontario objected that the federal government did not actually have the legislative power to pass some of that legislation. The dispute went to the Privy Council, where their lordships agreed with the state. Their lordships said, "It must not be thought that the result of this decision is that Canada is incompetent to legislate in performance of its treaty obligations. In totality of legislative powers, Dominion and provincial together, she is fully equipped. But the legislative powers remain distributed, and if, in the exercise of her new functions, derived from her new international status, she incurs obligations, they must, so far as legislation be concerned, when they deal with provincial classes of subjects, be dealt with by the totality of powers. In other words, by cooperation between the Dominion and the provinces." From this case, we learn that in federal nations, only the national government can enter into treaties, but depending on the constitution, it may require cooperation between the federal and state governments for those treaties to be implemented.